Our next case is State versus Pajestka, I will say, and hopefully not be terribly far off. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
Your Honor, if necessary, 5 minutes.
Okay, I'll be keeping time up here, so I'll let you know when you're down about a minute left in your regular time. Don't worry about that.
Thank you.
The arguments are being recorded. When you present your argument, please introduce yourself. Please make sure you speak loud enough for us to hear you when the recording to pick it up. And please make sure you stay behind the podium because we lose you if you start wandering away from the podium. You should not use the name of a child, a minor, or any victim during your argument. You can refer to them by initials like the child, although don't really have anything like that in this particular case to be concerned about.
Correct.
We read your briefs and are ready to proceed whenever you are.
Your Honor, thank you. Attorney Joseph Pajetka on behalf of Mr. Pajestka. As stated, 5 minutes if necessary. I don't know that hopefully I do not need it. In coming to the first assignment of error, which again, we're asking to adopt all the factual findings that were found in the first appeal. The first case was reversed, remanded to the Court of Appeals, and to the trial court, and now we're back here. The first assignment, which was not ruled upon in the first issue, goes to the expert witness. I'll absolutely agree that there was a violation of 16K before the first trial. It seems service was off. I don't think that we could argue with a straight face that 16K was not complied with. However, the Supreme Court of Ohio in State versus Bellamy says that essentially doesn't matter because this case was ultimately reset for trial. Service was perfected. The expert's report was given under 16K. There's no dispute, I think, from the city that they had in their possession that report well in advance, almost 6 months. I went to law school to avoid math. 5 months in advance of trial. I think the main thrust of the city's defense is that defense against this assignment of error is it wouldn't have mattered because they wrapped the A1D charge into the A1A charge. However, when we read Dr. Bellato's report, which is in the record, Dr. Bellato would have testified to two things. He would have testified first that that .093 would have been, in his expert opinion, more like a .75. And then secondly, when he viewed the field sobriety test, when he viewed the videos, when he viewed the evidence of impairment, that he saw no evidence of impairment. And that's the second to last paragraph of his expert report. So Dr. Bellato's report goes to both charges. It goes both to the A1D charge for the .093 blood drop breath test, and then to the actual was there impairment under A1A. So the deprivation of and the denial of the ability to present that expert opinion deprived Mr. Pajestka of his right to a fair trial. It should be remanded again, and this time a trial ordered on that issue.
Did the prosecutor raise some issues to the, other than the timing of the expert's report, some issue to its admissibility beyond that were not ruled on by the trial court?
Your Honor, I admittedly do not recall. I believe that the only issue that was raised was an motion in limine. There was never a 702 or a Daubert challenge raised to Dr. Bellato's credibility. I mean, he's testified for both the state U.S. attorneys. He's testified for both sides. I don't believe he's ever been subject to such a challenge, and in this case there was no challenge ever filed to the admissibility of it based on the science that he used. It was only in the trial attorney's failure to properly serve under 16K. There was no, and that's how the judge ruled. The judge ruled that essentially I ruled it was out previously, so it's still out now. And the judge specifically said, I'm not even going to hear arguments on it, even though he had originally said, I will hear arguments on it if you want to later. So the judge denied trial counsel the ability to perfect the record as to that. But there is enough in the record, and State versus Bellamy is almost the identical situation, just flipped on its heels. In State versus Bellamy, it was the state of Ohio who improperly filed and missed their 16K deadline. The case was reset. The trial judge, just as the trial judge here said, not even going to hear arguments on it. I already ruled it's out. It's out. The Supreme Court of Ohio said no. Once that case got reset, the clock started ticking again. So in assignment of error number 1, I think that resolves essentially what we have here before us, with the exception of assignment of error 2. This is the first time in my career as either a prosecutor or a defense attorney that I've ever seen a standardized field sobriety test split in essentially a third, and still ruled that the rest could go in. Under 4511.19G, G. And that's a big code section, as well as D. The test is only admissible if it's found to be in substantial compliance with a national standard. The national standard here is the NHTSA standard. The NHTSA standard for the horizontal gaze nystagmus test lays out 3 tests that must be performed in order, and they must be performed to get a complete battery, a complete result for the test. Here, the trial court found that 1/3 of the test was done improperly, but didn't make the next finding, which is the rest of the test needs to be thrown out. It's a logical problem because when the court, and I know this court has taken judicial notice of the NHTSA manual, the trial court below did as well. And when you look at section 8 of that manual, section 8 of that manual ends with, if any one of these components is changed, the test is rendered invalid. So here we have horizontal gaze nystagmus test, which is supposed to produce a possible 6 clues, and 2 of those clues were removed. Which then made it odd at trial because then the officer was testifying untruthfully. And I don't mean that to say he was perjuring himself, but he was testifying untruthfully when he testified that this test only has 4 clues and we found 4 out of 4 clues, which is not in compliance with what NHTSA says or how NHTSA teaches. So that test should be excised on remand as well.
I recall the state argued that because there's no objection at trial to the 2 prongs coming in, if you will, and you don't argue plain error, that you should lose on argument number 2. What would you say to that plain error argument?
That's not correct. That's not the appropriate standard. This motion, the standardized field sobriety tests were properly challenged and preserved by filing of the motion to suppress. Under Criminal Rule 12I, any such motions made in advance of trial, properly raised and ruled upon, preserve error under harmless error standard rather than the plain error standard. And here, there's no way that it could possibly fall by the wayside, especially when the state relied so heavily upon it. If you take that out, what do they have left for impairment? They have somebody who on video, I think objectively looks fairly sober, and the video is part of the record. I would ask that you, I'm sure you've already watched it. It's the standardized field sobriety test and the testimony there, plus the breath test that ultimately sink Mr. Pajestka. As it relates to assignment of error number 4, this is the issue that was remanded from the first case to determine whether or not the prosecutor made improper comments prior to trial or during trial, and if those improper comments were made, did they prejudice a substantial right? That is not the test that the trial court applied upon remand. Upon remand, the trial court adopted a different test than this court had previously ruled on. It looked at it in terms of whether or not this was malicious prosecution or something of that form. Vindictive prosecution, I think, is one of the phrases that the court used. This was not the correct standard and not the correct test, and this court reviews that de novo. First, is the right to testify a substantial right? I think we all agree it is. U.S. versus Weber says that it's the defendant and only the defendant's choice. So the second prong, I think, is easily proven. It's a question of not whether the first prong is proven, whether or not the comments were improper. And the prosecution in this case kind of wants to have it both ways. In their motion in limine regarding the expert's report, they're claiming jury trial starts, the trial start day of jury selection. And once the jury selection starts, that's the start of trial. But when we come to assignment of error number 4, they're saying, no, jury selection starts, or jury trials start after the jury's sworn in and opening statements are being given. You can't have it both ways. And here, we have jury selection starting, and I think in a context of a normal person, a normal citizen, Mr. Pajestka is there, he's at his jury trial. For some reason, the prosecutor says she's concerned with his counsel's inexperience, so she goes to the second chair defense attorney, rather than to attorney Aaron Schwartz, who has 22 years of experience. It's on the record he's tried 50 murder trials, and talks to him about it. It's a very almost unbelievable reason for why she brought up whether or not he was going to testify. And if we look at what the city is really saying, he's going to be prosecuted for falsification if he tells the truth. That's really what it is, and that's what she was saying. Because what would his testimony be that the city was so afraid of? It was afraid of him getting on the stand and saying I had something to drink at my mom's house. That would be in the city's mind, because if you look at the closing argument from the prosecutor, that is what she believed happened, and that's what she was afraid of the testimony coming out. So that would be him testifying to a true statement. But the real question is, could he have even been charged with falsification?
And I only have about a minute of your time left. And let me ask you this about that question.
Sure.
Before you get to what your point. There was a hearing in front of Judge Carroll. Is that transcript before Judge Carroll, before the Court on Appeal? I could not find in the record, so it was unclear to me if it is. Do you recall having that prepared for the court?
We did ask it to be prepared. I have a copy of it, so it's in my record. I don't know.
Okay, fair enough.
I have a copy of it for when I was provided when the record was prepared, so I don't want to assume that it was prepared, but I will verify that once I leave here. His testimony was taken from two individuals who testified to the threat being made. The prosecution denied that happening. The city brought in a witness who she testified she doesn't even really know why she was there, and which goes into our assignment of error number 3. The record shows that I talked to her prior. She had no idea what she was even testifying to, so it was kind of a trial by ambush witness. And then after she testified, we searched and we found that probably because of this case is years old, and she testified she didn't really remember. So I would.
And you're now in your rebuttal time.
Yeah, thank you. I reserve the rest of my time, and I'll address whatever I was going to rebuttal.
Thank you, Your Honors. May it please the court, my name is Bob Campbell. I'm an assistant prosecutor for the city of Medina. I'm going to address these assignments of error in reverse order. I'm going to start with assignment of error 4 because it illuminates this entire case and this entire appeal. It's concerning to the state of Ohio that Mr. Pajestka claims to his ever-changing story of what happened between Prosecutor Philbin and defense counsel. A conversation was had in which Attorney Caro indicated to Prosecutor Philbin that it's possible that the defendant would testify in this case, and she pointed out that, boy, you know, he ought to be careful because if he comes and testifies to something different than what he says in the police report, where he said to the police officers, he could be looking at the potential of a falsification charge, which is absolutely true and absolutely correct. While
Counsel, I was going to ask you, is that what she actually, how she actually said it, but evidently there's an issue with the transcript.
Well, I don't know if there's an issue with the transcript, but I will tell you that there was a full hearing, and Judge Carroll made some very specific findings of fact based on that. His findings of fact were that the testimony of defendant's attorneys at the December 19th, 2022 hearing were inconsistent with the facts in the record. Judge Carroll found either it did not happen the way counsel testified, or defense counsel were not concerned about a conversation with the prosecutor in the presence of jurors about potential falsification charges. Judge Carroll found testimony by defense counsel were inconsistent, vague, and at times evasive. He concluded upon review of the record, including the demeanor of the witnesses, and by the way, Prosecutor Philbin testified at this hearing too. He did not, Judge Carroll did not make any findings about her testimony being evasive or inconsistent. Upon review of the record, including the demeanor of the witnesses, the manner of responding to direct questions, and undisputed factually incorrect statements by defense witnesses, the court finds there is insufficient credible evidence to support the motion to dismiss. So regardless of what law we want to apply, Judge Carroll had found that the allegation was not supported by credible evidence. That should be the end of this court's review of that. Transcript or no transcript, this court's not in a position to substitute its factual findings for the factual findings of the
But
court.
wouldn't we at least accept the factual finding of Judge Carroll, which seemed to be there was a conversation sometime the day before voir dire, saying, look, what you've indicated, if your client
Yes.
testifies this way, it could be falsification, he needs to be careful. Shouldn't we at least review it under that factual setting, what Judge Carroll seemed to have found?
Yes, and that is every defendant's dilemma. The defendant does not have a right to lie.
But he does have a right to testify.
He does, and he could have testified in this
Well,
case.
I was just gonna say, in regard to the right to testify, whether that's how the prosecutor meant it or not, the point is, you're saying if you testify, you might be charged with falsification.
Correct.
Okay,
Because if you testify under oath to something different than you told police officers,
but that happens every day. Defendants, the prosecutor is usually ecstatic when somebody wants to take the stand and say something different, because they can impeach them with their
Sure.
prior inconsistent statements and their credibility is thrown out the window.
yeah, absolutely.
So why would she bring up falsification?
I guess no good deed goes unpunished.
Well,
I mean, look, in this trial, the whole basis of this expert, Bellato, was to say the BAC machine was wrong when it tested Mr. Pajesska's breath at .09. And the reason Mr. Bellato would say that it was wrong was because Pajeska told him he only had 2 beers. Okay, so he was going to, and quite frankly, if I was trying the case, I would have welcomed it. I would have. Because both Mr. Pajeska and, I don't know if it's Dr. Bellato or what he is, I know he's not a medical doctor, both would have looked foolish attacking the breath machine based upon the defendant's statement that he only had 2 beers when he had told the police officer he had nothing but coffee. Okay, so, but in any event, and then to go to, so that was a dilemma that Mr. Pajeska had, whether it was stated out loud or not. He had to be concerned of that, and whether other prosecutors chose not to file falsification or perjury charges when people lie, it doesn't mean that therefore there is a right to lie. And when you say one thing one time and one thing another, both of them can't be true.
exactly, except that when somebody is actually discussing with defense counsel their right to testify. That's where the rub comes in, right?
Well, I would hope that defense counsel would have advised him of that well before trial.
Well,
Look, Mr. Pajeska, we can get you on the stand up here, but the problem is everything you're gonna claim to testify under oath, you denied to the prosecutor, or to the police officer when you were trying to get out of this OVI on the scene. So we've got a problem. We can either have you come up here, but you may be subject to more charges.
But-
But
Well-
that's something that defense counsel would have to say with this,
Right.
their client.
So,
It's different.
I don't well, I guess what I'm saying is I don't see what the difference is.
Well, the difference may be, I think what Judge Sutton's getting at, the difference is when you have a prosecutor, it could be regarded as a threat. You better not take the stand, because if you do, whether you get off on this case or not, we're gonna charge you with falsification, and you're still gonna have to pay the consequences.
Right, but that's not what was said. And in fact, when defense counsel testified to that at the trial, Judge Carroll found them to be unbelievable, not telling the truth. That's what the finder of fact
But she
found.
admitted, the prosecutor admitted she said that. The prosecutor admitted, she said you can be charged with
This story
falsification.
grew. This story grew. When it was first alleged, first of all, when the statement was made, there was no objection to it whatsoever. Defense counsel went on with their day. They
And this was with a young attorney?
Well, both attorneys, if you believe them and their testimony, testified they were aware of it immediately when it was said.
But who did the prosecutor speak with?
Mr.
Originally?
Kara,
Okay, the young attorney.
yes. There was nothing said about it, there was no objection, nothing was said to the judge. The next morning, when they came back to resume the process of jury selection, then they said the statement was made. By the time they were testifying, they said the statement was made, it was repeated in a lobby, and then it was said in front of the defendant in the courtroom, which was physically impossible because the courtroom was never vacant because they were in COVID protocols. And potential jurors were spread out throughout the courtroom.
I guess what I'm saying is, why does that mean anything? Why is that relevant if they did it in front of this one, or if they did it in front of that one, or if they did it here or there? The point is, the prosecutor admits she said that. She said
Correct.
you could be
There's
charged
nothing-
with falsification.
That
So why does it
you could be
matter?
charged with falsification. There's no, it's a true statement. There's nothing inappropriate about saying that. She said something that was absolutely true. So, and if defense counsel hadn't anticipated it and were shocked, that's on them. But they shouldn't be surprised with hearing that if your client lies on the stand, you could get more charges. That's defense attorney 101.
We have you started some case law that basically says you don't have the right to commit perjury, and some of our cases have said that.
Correct.
Is there any case law that discusses the same thing as far as on a falsification charge rather than perjury?
I believe those are wrapped together. I can't speak to whether or not they mentioned specifically falsification.
Well, falsification is not under oath.
I'm sorry?
When he spoke with the police officers, that was not under oath,
That's correct.
whereas perjury is under oath.
Correct. Correct. So, I don't believe any court has ever found that the falsification statute's unconstitutional to say that a person has a right to lie to a police officer if the elements of the falsification claim, are met. As far as, the HGN in plain air, a defendant can't not object at trial to something coming in and then come in and expect, and not argue plain error. This court has a case law that says you're not gonna create plain error, you're not gonna make that argument for.
But he filed a motion to suppress.
He did, the court, allowed that, and then when, they were testifying, there was no objection to it.
Well,
So he invited that, it was as if he was they invited that.
I'm trying.
Secondly, as far as the
I'm
HGN goes, I disagree. There are 3 specific scored parts of the HGN. One has nothing to do with the other. So if there is a lack of smooth pursuit, that has nothing to do with onset of nystagmus prior to 45 degrees. If there's sustained nystagmus at maximum deviation, that has nothing to do with onset prior to 45 degrees. Onset prior to 45 degrees is its separate thing. So this jury did not hear that there was any additional indication of impairment. In fact, the onset of nystagmus prior to 45 degrees is often not seen in people who are over 0.08 or over 0.09. Those usually are seen at higher numbers over 0.05, so or 0.10. So that evidence actually was beneficial to the defendant, that there was only 4 out of the 6 clues instead of 6 out of the 6 clues.
counsel,
Yes, sir. Ma'am.
doesn't that, the whole point is it goes to the reliability of the test, how it's performed.
Goes to the reliability of the onset of nystagmus prior to 45 degrees. It
Well,
has
it goes to
nothing to do with the reliability of looking at lack of smooth pursuit. It's a completely separate standard. They're not looked for at the same time.
So those are not indicia of the reliability of the results of the horizontal gaze and nystagmus test?
No, not the one prong, if one portion of that test is done improperly, it has nothing to do with the rest of the test if it was done improperly. It's not like the walk and turn where it's a one pass proceeding, right? Walk out, walk back. There are 3 separate scored parts of that test that don't have anything to do with the other 3.
So how many clues did he find?
And you have about a minute left, Council.
Thank you. 4 out of 6. The 6, it would be 2 for each eye on lack of smooth pursuit, 2 for each eye on sustained nystagmus at maximum deviation, and then the lack of smooth pursuit or the onset prior to was not testified to. Your Honor, this is the state asks that the court defer to the issue 4 is a abuse of discretion standard. 2 separate trial judges reviewed this. Both that came to the same conclusion. One reached that conclusion by completely disregarding the testimony because it was unbelievable. So we ask that the court affirm this conviction. Thank you.
Thank you.
I guess kind of addressing things in reverse order again, as it relates to the HDN, it's traffic rule 11G as well as criminal rule 12, state versus La Rosa, the filing of a motion to suppress or raising any evidentiary issues prior to trial preserves it for appellate procedure later. Another case is state versus Mitchell-Hartman that I prevailed in the Supreme Court on. The state's defense to Mitchell-Hartman was, well, I didn't object after trial started, but we litigated the issue in Mitchell-Hartman as a 404B issue. We litigated that for days in the trial court, and the Supreme Court of Ohio said it's ridiculous to make defense counsel raise it again after a trial court has already ruled on it. We raised it, made a record of it. Same thing here. Suppression was raised, the trial court made a ruling. There's no reason to come at it again. You have to show respect to trial courts. When they make a ruling, they make a ruling. Here, the NHTSA manual itself says that the first test is substantial compliance. And what the city just stated is not true based on the NHTSA manual. The NHTSA manual talks about what are called arrest decisions and arrest points. Each test is not an independent test that stands in itself. It's something that officers have to take in the totality of the circumstances for the entire test. It is one complete test that has individual portions inside of it, and that's how in session 8 the NHTSA manual describes it. I know that when I teach it to the officers, because I'm an instructor, it is, when you read it, the plain language of the manual says that it is a complete test, and you have to have substantial compliance by law to be admissible at trial. If you excise a third of any test, that gets you to like a 66%. I don't know about you folks, but when I went to school, that was a failing grade. And that this would be a failing grade here. When it comes to Dr. Bellato's testimony, he is a medical doctor, he's a pharmacologist. He has, when you look at his CV, he attends and treats at the hospital. He's there in real medicine, doing real medical tests as a toxicologist, a pharmacologist, and a chemist. He is one of the most decorated experts that both the state of Ohio and the defense use. When it comes to the statement made and the threat made by the prosecutor, as this court notes, she has admitted she made the threat. And we have to look at...
Well, she didn't admit to a threat. She admitted informing the defense attorney that he was subjecting himself to a possible falsification charge.
If the court goes back to the first appellate argument we had, where she was present in this court, she admitted at that point it was a threat. And when this matter was brought up, because it got brought up by the seasoned attorney as soon as he learned about it, and he went into chambers, is what the record shows. Immediately upon hearing about it, he went into chambers. It's not something that went on with our day, or it was just pushed aside. They addressed it immediately, the court broke for the day, and then they came back the next day to address it. As well as a discovery violation that kind of occurred at the same time, which we're not here on, but all of these issues were ongoing at once. What's important is that when we look at, and it's a de novo review on a constitutional challenge, it's not a abuse of discretion where you have to accept the trial court's facts as true. And in this case, you shouldn't, because for instance, on page 8 of the decision, Judge Carroll found that no trial even occurred in this case. He said there's no issue here because there was never a trial. And that is on page 8 at the bottom.
What did he mean? I'm trying to understand his opinion. Did he just mean there wasn't a trial that day, but eventually there was one, this all got continued, so there was a trial right then on that date and time?
All throughout his decision, he talks about there being no trial, but there was a trial. And that's important, because when you're considering whether or not to accept the findings of fact from a trial court, fact like that, that's a big fact. That's in fact the entire point of the argument, is that the falsification, threat, or warning, however we want to categorize it, is still improper. Because again, look at what the falsification would be for doing.
And you're about out of your time. Let me ask you this. If we were to rule in your favor on any of your issues,
Sure.
are each of your issues that are asking for a new trial?
The
Or
first
are you asking
two-
for any other remedy?
The first two issues would be a remand for a new trial. The third and fourth issues would, well, the first three issues would be for a new, no, let me correct myself. The first two issues are for a new trial. The third issue would be another remand to supplement the record, which I don't know that we need to do. The fourth issue would be a complete dismissal of the charges. But ending on the falsification, and as this court has experienced, witnesses change their statement every day in trial. That is the purpose of cross-examination. And I would ask you, looking at your own experience, how many times has the state of Ohio ever prosecuted a witness of their own for changing their story from what they originally told police? It doesn't happen. But here though, the prosecution would be for telling the truth. And they knew about it on scene, because his statement was, I had nothing to drink today. Nothing to drink today. That was at 12:45 a.m. He was being cute. He had nothing to drink today. But he then blew over, so the officers knew that he
And
blew.
your time is up, if you briefly conclude.
I will conclude quickly. His BAC immediately blew that into question, but then he was gonna come in court and admit, because we have the expert report.
Thank you.
That he admitted that he had
Thank you,
ignorance.
counsel.
Thank you.
The court will take the matter under advisement and issue a decision in due course. The clerk court will mail a copy of that decision to you when it's released, and you also can find it on the Ohio Supreme Court's website. With that, I do want to thank you both today for your presentations on behalf of the court.
Thank you.